Good afternoon. Welcome to the Thursday, April 18th, 2019 meeting of the Metropolitan Area Planning Commission. And I would like to ask for public announcements, please.
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission and the Wichita-Sedgwick County Board of Zoning Appeals would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available in the lobby of this conference room. The Planning Commission's and the BZA's bylaws limit the applicant on a zoning, subdivision, or variance application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the chairman may extend these times by up to 2 minutes. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission and the Board will be retained by the Secretary as part of the official record. If you are not speaking but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission and the Board are interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct its own additional public hearings on these items. The decision of the BZA is final. Any appeal of a decision of the BZA is to district court.
Okay, with that, we will move on to agenda item number 1, approval of the MAPC meeting minutes from April 24th, 2019.
Second.
Okay, I have a motion by Mr. McKay, a second by Mr. Joe Johnson. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 9-0. On to agenda item number 2, consideration of subdivision committee recommendations. Sub 2019-00010, one-step final plat, Harry Street Townhome Edition. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we will take that item on consent.
Move to approve. Second.
Okay, I have a motion by Mr. Warren, a second by Mr. McKay. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 9-0. Agenda item number 3, public hearing vacation items. 3.1, VAC 2019-00001, city vacation of easement for the county jail entrance on property zoned LI. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we will take that item on consent. Agenda item number 3.2, VAC 2019-00002, city vacation to reduce the 30-foot side setback to 1 foot and rear 20-foot setback to 2 feet for the construction of an in-ground pool on property zoned SF5. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? We will take that item on consent. Agenda item number 3.3, VAC 2019-00003, city vacation of the east 50 feet of the west 230 feet, complete access control to allow one drive on property. Mr. Bill Johnson.
It's Bill Johnson. I got to abstain from this item.
Okay. Did you want to hear this case, though?
No.
Okay, is there anybody in the audience that would like to hear this case? Seeing none, we'll take this item on consent. Agenda item number 3.4, VAC 2019-00004, City vacation of 2 10-foot utility easements to allow site improvements for a convenience store on property. Is there anybody on the commission that would like to hear this case?
Application's deferred.
Been deferred.
Oh, I'm sorry. I see, deferred indefinitely per agent. Sorry about that.
I move for approval of 3-1, 3-2, and 3-3.
Second.
I have a motion by Mr. Joe Johnson, too many Johnsons. And a second by Mr. Hartman. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 10-0.
901.
Oh, we have one of nine.
10-0,
Okay, yeah.
901.
It's a good thing you guys are keeping me in line. Okay, moving on to public hearings, agenda item number 4, case number CON 2019-00002. Conditional use to permit an 80-foot tall wireless communication facility on property. We will hear that case. Agenda item number 5 has been deferred to 6/6/2019. Agenda item number 6, case number CON 2019-00007, county conditional use for a temporary rock crushing operation on 45 acres zoned LI and RR. Is anybody on the commission that would like to hear this case? Seeing none, is there anybody from the audience that would like to hear this case? Yes, we will hear this case. Agenda item number 7, CON 2019-00008, city conditional use for an accessory apartment on property zoned SF5, single-family residential. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we will take this item on consent. And agenda item number 8 has been deferred indefinitely.
Move to approve item number 7. Second.
Okay, I have a motion by Mr. Warren, a second by Mr. Klossmeyer, is that correct? Yes. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 10-0. Okay, and then we will go back to number 4. And we, yes,
It'll be out
yes.
of order if we heard 6 first. I think most of these people are here for 4.
Would that be okay for the commission to hear item number 6 first? Fine?
Brother, I gotta get out of here as soon as possible.
Oh, you're
I'd like
okay.
to hear 4 first, so I can
Want
get
to hear
out.
4 first?
I have to leave, I explained it to you.
Okay. Thank you. All right, Dave.
Thank you, Madam Chairman. Dave Yearout with staff. Conditional use 1902 concerns the request to replace an 80-foot tall wireless communication facility on property at 902 West 9th at the northwest corner of 18th and Woodland. I will briefly go through this because I know you've seen most of this stuff before. This is the location at the corner of 18th and Woodland, and outlined in blue is the location of where the proposed cell tower will go. As you can see, the surrounding properties are all zoned limited commercial. This is an aerial showing the location of the proposed compound that would house the proposed cell tower. The comprehensive plan for the area. This is the revised site plan that has now been provided to show where the proposed tower would be. This is the location in relation to the compound for the facility based on the lease legal description. This is the protest. As you know, this was heard, and this case has been returned to you from the city council. The protest that was filed within the statutory protest period, we have an 81.17% protest. It's outlined in red of the landowners who signed protest petitions within the notification area that own land that count towards determining whether this becomes a protested action before the city council. This is still valid. This is a blow-up of the subject property. This is the larger map showing all the protest petitions that were filed And you can see we've got one as far away as almost a mile to the south and west of the location. An aerial photo showing the property. The proposed tower would happen roughly about in this location. This is looking west at the site. This is what is immediately north, the blockhouse that is on the land zoned LC. This is that property as well. The existing single-family residence that is at the west end of the property that is zoned LC, but it is zoned commercial. And it is the zoning category that counts with respect to compatibility setback issues relevant to this case. This is the property looking north along Woodland. This is the driveway coming into the property off of Woodland, and you can see what it looks like to the north. This is what is immediately across the street on the east side of Woodland as you're looking east. And then this is kind of looking southeast from the site. This is 18th Street, and where did that go? And this is Woodland. This is the southeast corner of that intersection. This property, as well as what is immediately to the south, is also zoned LC. And that's what's across the street south, which is a commercial office building. Looking east along 18th, and we're across on the south side of 18th looking at the site. This is the commercial building owned by the landowner, and it is right behind this building that the proposed tower location is at. And then this is looking more west along 18th. This is the upholstery shop, and the end of the commercial zoning is roughly right here. This is the property that's immediately to the west overall of that area, and you can see they've got a 3-car garage that's adjacent to the property, and the house sits over here at Burns. So that is the summary of what's going on. As we indicated, this is a return, so the issue before the Planning Commission is a reconsideration based on what the council asked. You should have gotten a rather thick packet of information in your packet. That is the material that was submitted to the city council and was the basis for this item to be returned, and that the council asked that you take into consideration. Within the evaluation of that were several items raised, which included the claim that we had inadequately addressed the statutes that we referred to repeatedly, which is KSA 66-2019. At your desks is a copy of that statute with red highlights that we went through and summarized that material to try to make the general comments on. The relevant section, particularly with respect to one of the claims, is that we had failed to clarify to you and to put on the record that within that body of law, although there are a series of items that are now by state law saying the city and county in any case, or the U, cannot take into account or use as a basis for making a decision whether to approve or deny, is a statement that there is still the ability to exercise your zoning authority. And we identified that. However, that statute in question, which is subparagraph J at the end of that statute, clearly states that it's subject to the limitations and restrictions otherwise outlined in the statute. There also was a question raised as to whether or not that whole statute even applies to placement of a tower on private property. That law only applied to placement of stuff in public right-of-way. It's our opinion that no, it applies to both. They're both defined in the statute, and both are addressed throughout in several places. There also was questions raised as to what constitutes an applicant, and the definition was made, and we highlight that in the definition section. It's our opinion that the applicant is anybody who is involved or identified in the application for a wireless facility or structure, which in our opinion includes agents and lessees. So they've got as much standing as anybody with respect to the case going forward. So all those things are relevant, and we want to put it on the record just so that you understand and hear. I don't know that we need to go through the detail of that, but that is there, and you've got that information. There are copies out in the lobby for anybody that wants to see what that says. But we try to point out repeatedly within that summary is that that statute, particularly in Kansas, lists a lot of things that cities and counties are now not able to take into account in making a decision, but you still have the discretion to make a recommendation for or against. As you know, in the staff report, we went through and addressed the reasons why we believe, after evaluating the material provided by both sides, as well as the state law and the wireless master plan that's now been adopted by the city and county, that on balance, the recommendation should be to recommend approval. We listed the conditions within that staff report. We further re-solidified those reasonings and rationale in our findings of support of the recommendation of approval. This is back to you to take into account the material that's been provided, and you then are charged with either resubmitting your original recommendation, modifying that recommendation, and also by state law, and I've got legal counsel here to say that, but I believe that as applied here, if there is no action today, your original recommendation goes back to the governing body without change. So with that, I'll be happy to answer any questions you've got right now, and I know we've got material and information to be submitted by both parties.
Okay, we will start with Mr. Joe Johnson.
What was our vote before?
It was,
N1.
yeah, to recommend approval under the conditions outlined in the staff report.
Steve, could you go back to the photo you had of where the actual tower is going to be located?
This one?
Do you have any idea how tall that power pole is that's directly behind there?
I do not. I'm guessing based upon, this one is a little shorter than the ones out here on 18th Street that I've got a picture that kind of show, well, there. And it's our understanding, this is 56 feet tall from what KDOT, or from what, not KDOT, Westar.
I think there was
had
another
provided.
photo of those that was a little bit better to look at. 'cause it wasn't
And
true.
I don't think this one's quite as tall.
Okay.
Other questions from the commission? Mr. Foster?
Dave, I'm curious, I'm trying to remember after reading through all of this, what differences are there still between the latest federal information versus the statute?
I don't know that, and I'm going to punt to Scott because he really handled a lot of that stuff, but I'm not sure there's a lot of difference between the two in what the state, or what the feds are now saying localities can do different from what cities based on the state statute, so.
Well, there are a few differences. The latest Federal Communication Commission declaratory ruling does in fact apply only to small cell facilities. So that's the primary difference is that the state statute addresses both small cell facilities and what are defined in the state statute as wireless support structures, which are monopoles like we're considering today on private property. The other clarification that the FCC ruling made is that the review time, the 150-day review time that cities are allowed to review an application for a wireless facility includes both the zoning and the building permit application. So both of those have to be reviewed within 150 days. Those are the two primary things that are different from the FCC ruling. There are a few others, but those are the two primary.
Other questions from the commission? Okay. Dave, thank you very much.
Thank you.
And if agent or applicant could please step forward, you'll have, if you'll state your name and address, and you'll have 10 minutes.
PowerPoint.
We all got notification and was contacted outside of what was sent in by the staff. emails and stuff like that, so I got one. I think everybody else basically got one too, so.
Gotta check your email.
Are you ready, Madam Chairman?
Yes, yes, sir.
Madam Chairman, members of the Planning Commission, my name is Greg Ferris. I'm here today. I represent APC Towers. We were here a few weeks back, and we went through several things. I think it's important to address a few of the things that have come up in literature that you may have read from the neighborhood. There's been a lot of noise about the state law, and I'm not a lawyer, so I'm not going to address the specifics of the state law. I will tell you that I made sure that our application was based strictly on Policy 10, the golden rules, and the policies for consideration of a conditional use by the Planning Commission and the City Council apart from state law. So when I made my presentation, I specifically addressed the need for service. Your original application had with it all of the information from T-Mobile showing a litany of information about the need for the tower. Even though staff has said state law doesn't require us to do that, we have submitted that. With me today is the RF engineer for T-Mobile who can address specific questions if you have that. Also with me today is George Wyrick and Justin Owens from T-Mobile. They are with their office in Oklahoma City, so they can address that specifically. There's also some question as to whether or not we looked at other locations, met with school district, actually spent time on the grounds of schools trying to find a location, was rejected by the schools. We met with two churches. The churches wanted to expand and didn't have ground for us to go on. It was rejected. If you look at the area around this, outside of the commercial area here and the commercial area on 13th Street, there really is not adequate other locations. So I think I documented that well, even though it said that I didn't. I think we went through that. The small cell technology was also addressed in my presentation. I'm not going to go into those details, but if you have questions about small cell technology, I do have 3 experts here. And when I say experts, I mean people that have worked in this industry for multiple years. They're either engineers or have worked in the industry for a number of years that can address the specifics of why small cell technology does not work in this location. And anything you hear about that is just opinion, and it is not based on anything in fact in the wireless industry. Finally, talked about some existing towers that are located in the general area. I will tell you that we are on those towers. And so it becomes irrelevant for us to even think about going on those towers. The only tower we were not on is the one at North High. And again, as I said, we met with the district and ran into different issues there. So the consideration of this is based strictly on, as I said, Policy 10. I want to go through those again and just highlight those. The zoning and character and use of the area. I think it's very important for you to understand this is a mixed-use area. There are not just commercial uses, limited commercial uses, but those limited commercial uses kind of push the envelope. I think you saw the picture of the area directly across the road. That's not exactly just a normally found in a residential area. That shows that this character is truly mixed use. It's not just a mixed use of office, of commercial and residential, but also commercial that is a little different than what you might expect in some other areas. I'll also tell you one of the most important things to understand about this zoning case is that it is in limited commercial zoning. Limited commercial zoning by the zoning code allows structures to 80 foot tall by right without any zoning or approval as long as they meet the setback criteria. This tower meets the setback criteria. An 80-foot tall structure would be consistent with the character of this area based on the zoning. I think it's important for you to recognize that as you consider the zoning and use of the character of the neighborhood. And finally, address Mr. Johnson. That tower is only about 35 to 40 feet tall. It is smaller. It's not a tall tower. The electric pole that you asked about, but the poles along 18th Street are 56 feet tall. Again, that we're not introducing something into this area that is not already there. So I think we certainly address that character. I think the second biggest issue is whether or not this affects nearby property. You have quote-unquote expert testimony provided that says that they have appraisers who generally think that there are issues with towers. They do not provide you with any specific data whatsoever when it comes to sales information, data information. I have provided for you, and I think you have a copy of that, of the executive summary of a appraiser's report that was done. I'd like to also, as I walk away, I'll submit this into the record. This is the full appraiser's report. It is 190 pages. It is detailed, and it comes to the conclusion from that appraiser's report that there is no impact. That is factual information. This is not opinion. This is based on hard evidence, and that's what we are basing our positions on today. So we do not believe, based on that, that there is any impact. Finally, also, in regard to that, and I thought it would be in staff's presentation as I provided it to staff, and I don't see it there, is a map that, and I don't know, I have it here somewhere, I'll find it, of towers that are in the area in a half-mile circles. Were you provided with that information? Okay, that's fine. I'll provide that into the record as well. There are 3 towers that are located in close proximity to this location, and if you draw a circle a half mile in radius from those and a half mile in radius from this tower, proposed tower, that virtually every square foot of that radius is covered within a half a mile of another tower. So to say that towers impact property values, if there was an impact, it's already happened. They're already there. They're already within a half mile. And those towers are 150 foot tall. They are not 80 foot tall. Finally, some of the reports that you have in your record is, that was provided to you talks about a study that was done in 2005 of what the impact of towers are in residential areas. I will tell you that a study done in 2005 in the wireless industry is outdated. As you know, and we all know, that what's happened in the industry in the last 14 years is significant, and that there are not information in Wichita that you're going to find appraisals based on the impact of an 80-foot tower, because frankly, we just don't have very many of those. I think there might be 2 that are 80 foot or shorter. So any of the information you hear are going to be based on the impact of 150 or 120 or 190 foot tall towers, which is what this community is used to having. The gain to public safety and welfare, I have provided this in writing. I'm not going to go into a lot of detail because I'm going to run out of time, and there's a lot of people who want to speak, and I don't want to run over on that. I will tell you that E911 isn't what they are portraying it to be. There is a lot more information, and if you have specific questions on how that works, I'll be glad to address that to you at the end of my presentation. Finally, I think it's very important to note, and I've outlined in much greater detail how this conforms with the wireless plan. It definitely, no tower ever will comply with 100% of the wireless plan, but this, I think I have cited 6 of the 8 or 9 criteria that we do comply with. We have no impact on community facilities, and I believe staff has reiterated that they recommend this, so the consideration of professional staff. I think when you go through what you're supposed to consider, forget state law, I mean, you can use it if you want, I don't care, but if you look at what you're supposed to consider for a conditional use permit, any conditional use, whether it's a tower or anything else, this clearly meets the criteria that has been outlined in the planning guidelines. I think I've demonstrated that. Finally, as I'll wrap up, I will present also I don't think you get provided the actual application that I submit. That application shows as the applicant APC Towers and T-Mobile. So T-Mobile is an applicant in this case, and therefore falls under the jurisdiction of anything else that you might consider. So I think that with that, I'll be glad to answer any questions you might have.
Thank you, Mr. Ferris. Questions from the commission?
Well, sure, certainly somebody's got to ask one question.
No questions? Yes, sir.
How much would a 60-foot tower reduce efficiency?
That's a good question for my RF engineer. Why don't you just come up and tell me, and I'll explain it to him. Just come on up. Question is, why would a 60-foot tower not work here instead of an 80-foot tower?
So it's the overall environment. It is not that effective if we go lower than what we have now.
Okay, RF frequencies in this area, if you drop it down to 60 foot, what you're trying to accomplish when you deal with housing structures is the penetration of buildings. Obviously, the lower you go, the less distance that you have with that power to penetrate. They have evaluated that 60 foot. They evaluated 100 foot, which it originally was proposed to be. And they felt like at 60 they could get the adequate coverage, but at 60 that does not alleviate the capacity issues that they're looking at trying to take care of.
Lawrence?
What is the consequences of not getting approved?
Well, if this isn't approved, then there will not be capacity issues. The area will experience capacity issues in the future as this grows. It'll experience some today. And what that means is if people want to use their data, we live in a different world. I don't use my phone as much as a lot of people. My son doesn't use a computer anymore. He only uses his phone as his computer. If he cannot download data, he's pretty upset. And I think that is the trend that's coming more and more and more, is that people expect when they use their phone that they can use that for whatever they want to. And what the wireless industry is trying to accommodate is people that want to use their phone for data. And what has happened is the capacity for that data is limited. So you have a tower at Twin Lakes, you have a tower at Waco, you have antennas on top of the buildings over in Riverview, and those are operating at or near capacity. And what happens is if you try to get download speed, if somebody else has already used up that capacity, you're not going to get that speed. Doesn't mean your phone won't work at all. It won't work the way that it's supposed to work. And it could be that it won't work at all if that capacity reaches a high enough level. So those are kind of what the issues are of what happens if you don't have enough towers.
Questions from the commission? Okay, thank you, Mr. Ferris.
And I will provide that map to you. I thought I had it here. Must be in my briefcase. I'll provide that to staff.
Madam Chair?
Yes, sir.
Well, it was noted in the literature that you have. You've had the executive summary, and it was made available here. It was made
Guys,
available to
We
you.
you
can't,
need to sit down. We'll do the procedure, and then we'll take care of you after the meeting.
That's what I'm asking about, is the procedure. That's the due process that I'm talking about here.
Mr. Thompson, if you could have a seat, please. We will address the concerns that you have. Thank you. So we're gonna go to the audience, and could I maybe just see a show of hands of who from the audience wants to speak on this issue? Okay. Yeah, I think there's 9. So thank you for raising your hands. So as we introduce representatives from the audience who would like to speak, you will have 3 minutes, and we'll ask you to state your name and address. What I would like to ask is, the commission has received lots of documents that we have spent an enormous amount of time reading over to be prepared for this meeting. And so you will have 3 minutes, but we would like for you to try to introduce things that have not yet been introduced in the prior meeting on this topic, as well as the things that, any new things that you might want to introduce that haven't been presented to us in these documents. So with that, I will ask whoever wants to go first to step to the podium and state your name and address. And again, you will have 3 minutes.
Good afternoon. My name is Claire Willenberg. I'm a 30-year realtor and president of North Riverside Neighborhood Association. and I appreciate your listening to our presentations. I'm not quite sure what happened to half of my slides that I presented, but we're kind of starting in the middle. I know a lot of the statements and data presented are subjective. So I'd like to introduce you better to our neighborhood and the character. Please keep in mind it says uses besides zoning. This map shows zoning. The area on the, excuse me, I'm not used to doing this PowerPoint type either. On the west edge of our neighborhood is single family. In the middle, to the right, where the tower location is predominantly TF3. The only, as you have seen before, light commercial are the 8 lots where the tower site is coming, and not all of those are commercial use. We have a church on LC, and we have what used to be in the 50s, a drugstore. It's now being converted to office and possibly residential. The only other is the Twin Lakes Shopping Center and a bank, almost on the outside edges of our neighborhood, small strip center, and a small strip center here. So we are, and just showing the use is not that mixed. It's predominantly residential. Definitely the surrounding uses. There's a limited commercial active building here. This building where the tower site is behind has been described as an active commercially used building. It's been vacant at least since '07. It has not had sewer service. Whoops, I went the wrong way. Since, oh, there's one. All right. Excuse me. Back up one. I'm sorry, I have an essential tremor. It makes it very difficult for me to use this. It is residential use directly to the north. It is 50 feet from the edge of the tower fence to this building. The tower site was moved over to 8 feet from this east fence so that it would meet some conditional use guidelines. Actually, maybe 77 feet
Ms.
is
Wilbur,
maximum.
your time is up.
Oh, I'm sorry. Can I please have 2 more minutes? Many of my speakers will be under.
How does, is the commission okay with giving her 2 more minutes? Yes?
She moved, she had 2 more minutes.
This is LC but commercial, but residential, LC but residential.
We don't need
sorry.
a motion, so,
I'm sorry. I thought that was.
no, I don't need a motion. I just kind of checking in. Thank you. Proceed, thank you.
Okay. These are the surrounding homes. 3 of them are potentially eligible for National Registry. I'm going the wrong way. We have about 4,200 people, 1,745 homes, 4 churches. 2 of them only inside the neighborhood have enough land that could be considered. Both pastors said they were not approached for any type of leasing for a wireless communication. 2 parks, 2 schools. We are a minority group, about 50% in our neighborhood. And it also, shoot. Please put up with my shakiness, I'm sorry. Line of sight to the fenced area is very evident from many of the surrounding properties, and it will detrimentally affect. I'm sorry if I'm considered a so-called expert. I've been selling commercial or residential real estate for 30 years. I called 4 of the realtors that live in the neighborhood without hesitation. They signed that it will affect. I called 4 appraisers because that's all I had time to reach out to. They agreed. The view from across the street will be of an 8-foot fence. These are views from the bottom one. Here is the backyard of the nearest residential property. It's not really a good look for them, or Property value, I went through that a little bit. We have 4 local and experienced appraisers, the only ones I could reach. And they signed it. Well, they are not able to give you a specific amount. We don't have any situations in Wichita yet. The building has been unused and vacant for many years, been an eyesore for the neighborhood. Adding the ground equipment of
Ms.
fencing will
Williver?
only,
Ma'am,
I'm done.
your
Okay.
time is up. But I'd like for you to remain at the podium just for a moment to make sure if there's any of the commission has questions.
I
So,
would love to address neighborhood opposition. Yes, sir.
Mr. Daly.
What is the age to be on the National Register?
50 year, the 1950s are now,
So most of the houses in Riverside
absolutely.
are,
Yeah, it's a very historic
be
neighborhood.
eligible.
Arc Valley Interurban used to run through it.
Mr. Daly, I understand the time length is 50 years.
But
Yes.
if
50.
if they have siding, there could be a number of things that could disqualify a home from being eligible on the,
National Registry.
to be put on the register. It just depends. We know there are at least 3, 2 that are on the street, the half block to the west, and then the one catty corner to the southeast. But when I drove the area, there are a number of those homes on the street to the west that have siding on them, which makes it more difficult for them to be considered appropriate for whatever that's worth.
Other questions? Mr. Foster.
There's a distinction between appraisal and market value. My question is, when appraisal value is determined, do they take nearby towers into consideration? Do you happen
Yes.
to know that?
That's what they are saying they do.
Thank you.
Other questions from the commission? Okay, seeing none. Thank you again for your presentation.
Hey,
If the
thank
next
you.
person would step forward and state your name and address, and again, you'll have 3 minutes.
Yes, pardon me. My name is John Carmichael. I live at 1475 North Leonette Street. It would be about 2 blocks to the west and about 5-6 blocks to the south of the location. I am here actually, though, because I am the state representative for the 92nd District where this application is being filed. I've served in the legislature since 2013. I was there in 2016 when the Wireless Siting Act was passed, and I've served on the Energy, Utilities, and Telecommunications Committee for the past 3 years. I will tell you that I seriously disagree with the city staff's interpretation of the scope of the 2016 ordinance. In fact, the city attorney's office provided to me this morning a new draft of an interpretation, but it's still a draft, so we'll just have to leave it where it is. Suffice to say, the 2016 law is titled and directed specifically at placements in right-of-way, not placements on private property. And in fact, to reiterate that circumstance, this year, the Utilities Committee passed a bill dealing with small cell siting. And as a part of that bill, an amendment was proposed to make it explicitly clear that the 2016 Act does not prohibit cities from denying applications on the basis of aesthetics being now the magic term in the FCC regs. The representatives from the industry, Verizon, T-Mobile, et cetera, uniformly said the 2016 Act does not prevent you from denying an application based on aesthetics. That is the position that the industry uniformly takes when they come to Topeka. It is only when they arrive here that they sometimes contend otherwise. But the fact of the matter here is the applicant has now made clear through Mr. Ferris's statement, but also through his April 11, 2019 correspondence to Dale Miller, is that, in his words, the most significant one of these is that state law does not apply to towers on private property, but only those in the right-of-way. The allegation was that my presentation relied on the state law. He says whether or not state law is applicable is not relevant because my presentation included the following, and he then describes the general zoning standards. So I would suggest, to the extent there ever was an argument that state law prohibited or precluded your denial of this application, the applicant has backed away from that position, no longer takes that position, and accordingly, it would be inappropriate for you to now deny the application on the basis of the 2016 law. I'd be happy to spend plenty of time with you telling you politically why it is that most likely, following the hearing in late March on the bill that I cited earlier, the applicant now says they are not relying upon the state law, but that's not material. If it's their position that state law does not require the placement of this tower, that's good enough for me, and hopefully the legislature won't have to readdress this problem next year.
Carmichael.
I'd be happy to respond to any questions that anyone might have.
Thank you. Mr. Joe Johnson.
Carmichael, are you for or against this?
Am I personally for or against it? I'm relatively against it. This is, I'll admit, a better location than the prior location that was on 13th Street adjacent to the park. I can't see this location from my house no matter what I do because there's trees in the way. So just being candid with you.
Mr. Daly.
I see that you have submitted Senate Bill 68, and from the backup paper that I got, I understood that it was soundly defeated. Is that correct?
Senate Bill 68 actually was a bill having to do with small cell wireless placement. And in particular, it deals with whether or not a franchise fee must be paid or whether, in fact, incumbents who paid a franchise fee don't have to pay a new wireless fee. Senate Bill 68 was passed. What was not passed was my amendment to amend the 2016 Wireless Siting Act to specifically say that bodies, authorities such as you, can take into account the aesthetics. And the reason that was defeated is the industry lobbyists uniformly said that's not necessary. You can already deny those applications on that basis, and accordingly, the committee did not make a change in the law. And subsequent to me offering that bill, the applicant here has withdrawn their contention that the 2016 law was applicable to this circumstance. Does that make any sense?
I just wondered why it was in the packet.
Oh, well, I didn't personally submit anything to the packet, but I think other people may have submitted things that I did. But the reason was to point out that in connection with the recent legislation on small cell placement, that an attempt was made to amend the 2016 law to make it abundantly clear that you do not have, that law applies to private right-of-ways, public right-of-ways, not private property. And the uniform position of the industry and everyone else on the committee was it wasn't necessary because that's already the law. The 2016 Act does not apply to this application, but the applicant now concedes or takes the position they're not relying on the 16 law anyway, so it doesn't matter. Anything else I can respond to?
Other questions by the commission?
Thank you for your kind attention. I appreciate it.
Thank you, Mr. Carmichael. Who would like to speak next on this case? We'll just come forward and state your name and address. I think you're the perfect person to present next.
Am I? Okay.
Just state your name and address and
Okay, my name is Debbie Potter. I actually own the property at 1922 North Woodland, which was built by my grandparents-in-law in 1950, Wesley and Leela Frederick. I'm a 10-year realtor as well. A couple things I wanted to address first is that Greg had said that it's much needed. I can tell you this last year I did a lot of work on my property flooring and such, and I was streaming Netflix and I was listening to audiobooks. I never had an ounce of trouble, not buffering, not slow, not anything. On the archived HUD website, which is still available for viewing, tall metal powers are considered a blight. And it is also still on the NAR website considered a hazard, and it does, the data on the NAR website has an abundance of articles dealing with the blight of towers and the effect on property values. But in my prepared statement, we have heard statements that utility poles close to this tower site are already up to 56 feet tall, and that the proposed monopole is not a lot taller. But a 20 to 30 foot on average addition is a full 1/3 in height addition to that pole. Add to this that there is a large antenna array on top, lightning suppression equipment, and that the base will be 35 by 45 foot area of wood, and the wood fence is 8 feet tall. This is an additional blight to the neighborhood because this monopole and equipment will be metal and significantly different and much more obtrusive than a telephone or utility pole that are just commonly in that area made of wood anyway. We've been told that the neighborhood trees will buffer the negative visual impact. There is one red cedar tree in the vicinity. However, the majority of North Riverside trees are deciduous. This means that the few located nearby will only provide limited screening, and then only for 6 months of the year. In regard to the building, shielding the view of the tower, this vacant building is listed on tax records as being 14 feet in height. The required wood fencing is 8 feet tall, which is more than half the height of the building. The building itself is 28 feet by 46 feet, which gives it a square footage of 1288. The fencing is 35 feet by 45 feet, which is 1575 square foot footprint. So if you think about this, the fenced enclosure will cover an area that is already 287 square feet larger than the building itself. One could argue that it will be the dominant structure on this lot. The base fencing and tower will stand out visually for many surrounding neighbors and to all who travel Woodland or 18th, and it will impose a visual blight upon North Riverside. I would like to add, I do also own another property on 18th.
Ms. Potter, you're out of time.
Okay. May I save my one property? At 641, 643 West 18th. It's about 2 blocks away.
Okay, thank you.
You have questions?
Any questions from the commission? Okay.
Oh, man.
Any questions?
I was ready for you.
Thank you. Okay, who would like to speak next on this case? Sir, if you'd state your name and address, and you'll have 3 minutes.
My name is Dan Zamalt. I'm located at 1828 North Heiserman. I am about 2.5 blocks from the proposed site. What I want to address is the kids that I see in the neighborhood, the ones coming in after school, the ones sitting on the street corners waiting for the school buses to come. And the term that applies to this is called attractive nuisance, is where my concern rests. Recently, there's been a incident in Pretty Prairie concerning an 8, a 10, and a 13-year-old, which pretty well covers the children that I see coming up and down that street. Attractive nuisance addresses the issues of responsibility when children are attracted to something that ultimately can cause them harm. It's an issue that came out in private pools, and now I believe it approaches this issue also. Children can climb fences. They can poke at things. They can get under fences. And I would care not to see any children fried in my neighborhood, or I'm sure you would like to see none fried in the city of Wichita. I believe it will be an attractive nuisance to children in that area that are looking at it and want to find out what it is. And more dastardly is what, in fact, makes it tick. And I don't need any more than that.
Thank you. Mr. Joe Johnson.
Just a quick question. Are you familiar with any other situations around town that attractive nuisance have created such a conflict?
Not where there has been death or dismemberment. I can tell you down at the end of my street on 13th, the major disfigurements, disfacements of the bridge has caused problems, and we're seeing it throughout the neighborhood.
Talking about the base of the tower frying
A
kilowatts?
tower? No, sir.
Thank you.
Other questions from the commission? Thank you very much. Okay, who would like to speak next on this case? You know the drill. If you'll state your name and address, and you'll have 3 minutes.
All right. My name is Beth Harshfield, and my address is 1911 Woodland. The current technology, wait a minute, this is not the right page. Let me go. Okay, here's our opposition, a summary of that. The current technology, I know Greg Ferris says it's not possible, but he also said it wasn't possible to not approve the tower on 13th. He doesn't see the options in the world. And I would like to debunk some of his statements. Current technology is 4G LTE small cell. It's cheaper, it's better performance, not intrusive. Plus, there's 300 of these already in Wichita. Oop, there we go. Douglas and Yale, Topeka and Lincoln. These are low-density areas, much like the area we're talking about. And we think that this is the wave of the future, not these obtrusive poles. Last time I spoke about my relationship to our property, which is right next, as you can see, this right here.
Ma'am, you'll have to stay at the microphone.
This right there is our property. It has not been included on any site maps. This is very disturbing to me because it's a two-story house. And I guarantee you, the people who live in this house will be much affected by this tower fence that is 20 foot away and this tower that is maybe 55 feet away. If it falls on our front porch. And also this property is also, we are billed on a residential rate. Our taxes are based on a residential rate, not a commercial rate. This has not been brought forward to anybody before by the map. Again, our use is, like I said, residential and commercial. And there you see the footprint, the corrected footprint. And then also, at some point, this tower was moved. And as the people who are in close proximity to this application, we didn't get any notification that all of a sudden this has moved. The information has been very spotty and confusing and difficult. You would think this would be a process that would be very clear and the people shouldn't have to fight for this information. And I know Mr. Ferris and Mr. Yearout have said that the service providers Greg can serve as a service provider. But if you look at the application, and we've spent a lot of time looking at this application.
Harshfield, your time is up. Do you need an additional 1 minute or 2 minutes?
Yeah, I'd like another minute.
Okay, thank you. If you'll give her.
There's
an additional 1 minute.
there's two signatures on this. Juan Castillos and Greg Ferris. APC Towers and T-Mobile are listed as an applicant, but there is no signature for them. And they have to have a service provider, according to state law that I read, for this application to be valid. And according to page 1 on the conditional use permit, it has to be complete for it to be accepted. This is a very incomplete application. If you even look on the map, it says Snyder. Snyder is not even involved in this. I think this is a shoddy application.
Ma'am, can you stay at the podium for any questions, please? Questions from the commission?
I would instruct everybody who has an opportunity to look at these applications, because some of them are not very well done.
I do just want to refer to Chapter 66 of the Kansas State statutes regarding Article 20 regarding telecommunications. Just for your information, if you look at item F, to ensure uniformity across the state with respect to consideration of every application, an authority shall not, and if you look at item number 2, it does say require information that concerns the specific need for wireless support structure, including the service to be provided from the wireless support structure, is to add additional wireless coverage or additional wireless capacity. I won't read the rest of that. Item number 3, evaluate an application based on the availability of other potential locations. So we can't consider other locations in the.
I didn't recommend any other locations, did I?
There was some recommendations about looking at other locations or
No, I
dictate.
just said you should look at different types of equipment.
Or dictate the type of transmission equipment or technology to be used by the applicant, including but not limited to requiring an applicant to construct a distributed antenna system or a small cell facility in lieu of constructing a new wireless support structure, or discriminate between different types of infrastructure or technology. So although we may hear some discussion here about us encouraging them to use the small cell technology, that's not in our purview to be able to dictate that to them. So I just wanted to make that.
I just think it's another reason to deny this application. There's many reasons which I've pointed out, and I just think that I would hope that you consider it.
Thank you. I appreciate that. Okay, who would like to speak next on this case? If you'll state your name and
My
address.
name's Madeline McCullough. I live at 810 Shady Way. What I would like to talk about is I don't even think this tower is needed. In the process of applying for this special use permit, Mr. Ferris has changed his mind several times about what this tower was going to do. Initially, he said it was going to relieve some of the capacity issues on the Twin Lakes Tower. That was in January. Later, he emailed Claire Willenberg and said this tower was to help the tower at 21st and Waco. In addition, he's talked about the tower at 17th and Broadway. Eventually, he got to the point where he started talking about, as he did today, the tower being for streaming and Wi-Fi. This quote, "If I had a tower that was close enough to me to be able to have capacity, then for $40 I could light up my whole house with internet. Now, for half the price, I can have faster internet than I would get from Cox." I would point out to you that Wi-Fi service is not the same as mobile communication. That is data streaming, that is movies, that's not phone service. In fact, the courts have ruled Wi-Fi service is not a system for mobile communication, and the availability of Wi-Fi has no effect on cell phone coverage. So what he's asking for is not even relevant to what the law addresses. Under the rule of the Telecommunications Act, cities are not obligated to approve towers for the purpose of Wi-Fi or hotspots. So I do not believe the city of Wichita should be afraid to deny this special use permit. He also talks about this signal gap, and so far this signal gap is hearsay. One of the a map that we, downloaded April 14th from the T-Mobile site shows the entire area as having excellent signal. Where is this signal gap? There are some tiny little areas north of 21st Street and over closer to McLean Boulevard that are considered only good, but there's no signal gap in this area. That's the points I want to make.
Thank you. If you'll stay there and let me ask the commission if they have any questions. Any questions from the commission? Okay, thank you very much. Okay, who would like to speak next? You want to speak next? Okay, well, I've got somebody that's coming up to the podium, so if you'll hop up after her. Okay, very good. And if you'll just state your name and address.
I will, thank you.
Thank you.
My name's Susie Cunningham. I live at 1329 Llewellyn Street. I've been here before. I have to put my glasses on. Towers. I think I bumped it. Up in the north end of North Riverside, this area is pretty much mixed race and low income, and Claire would have gotten to the exact demographics, but we didn't get to, so you'll have to bear with me on this part. Towers are considered industrial use by the Unified Zoning Code, and just like most other industrial uses, tall towers too close to residential areas degrade residential property values and create unnecessary risks. One would have hoped that planning's most powerful tool, land use zoning, would shield all residential neighborhoods regardless of economic, racial, or ethnic characteristics, because zoning is designed to protect public health, safety, and welfare. However, we know that developers and utilities frequently locate in low-income communities and communities of mixed race, suggesting that zoning may not shield these communities as well as others. We also know that in areas that are ethnically diverse usually offer the path of least resistance, and I can tell you, this isn't one of those cases. And I haven't moved this, have I? Okay. You've heard about the realtors before. I'm a retired real estate broker, and I may not have data from before and after, but I personally and carefully vetted the research that was turned in before to make sure it was not subject to industry bias. I also made sure that there was in that research before tower siting and after tower siting sales included, and that would be the Bloomquist lock that was done in Kentucky, and it was all done through the Kentucky University. I also want to say that as a realtor, I pulled up to a house just north of the zoo, and my people would not get out of the house because there was a giant tower there. They would not even look at it. It happened again on the west side on Hoover Road. There was a really big electric pole they look the same, they just have different accoutrements at the top. They too were mad that I showed them all the inside pictures, but I didn't tell them before they took off work to go look at that. So if you think that people are just happy to live next door to them, you're wrong. And to dismiss professionals.
Ms. Cunningham,
I'm done.
You're out of time.
Thank you.
Can you remain at the podium for questions? Is there any questions from the commission? No? Okay, thank you very much. Okay, sir, if you could state your name and address, and you'll have 3 minutes.
Afternoon, I'm Vernon Harshfield, live at 1330 Amadon. I co-own the property directly north of the cell tower proposed location, 1911-1913 North Woodland. This proposed tower will basically be right in the backyard of the residential house and studio. So I'm terribly concerned about the potential hazard the tower would create for any residents or people occupying the house, yard, the studio there. It's outrageous to even consider this. I'm sorry, I need to advance this on, please pardon me. Mr. Ferris had mentioned how there's a 190-page document for backing his comments on the value of the property as affected by the tower. Doing a little research on Valbridge, whose this report is being provided to Mr. Ferris. Valbridge appears to be kind of a who's who of the wireless or the Wi-Fi industry. Their client list is like a who's who of the Wi-Fi industry. So in my opinion, really taking this 190-page document is like kind of, if I may, having Monsanto recommend Roundup sprinkles on your breakfast cereal. There is a list of some of their clients, and once again, it is all part of the Wi-Fi industry, their clients. And here is a map provided by the Planning Commission showing the sensitive area that they recommend for no communication towers to be placed. I assume this is something you all have generated at some time, and to why now the character of this community has not changed. What has changed? The need for taller, bigger towers because 911 needs more access because of phones, meeting better service off humongous towers, 80-foot tower that is automatically granted another 20-foot extension, 20-foot automatically added onto the 80, not to mention the additional amount of 5 to 10 foot. I don't really know. I'm sorry, I'm not the expert. Other than I do know the 20 foot is an automatic extension.
Sir, your time is up.
May I have another moment or two, please?
I'll give you 2 more minutes.
Thank you. As you all know, there's other placements for these towers rather than on personal property. They can be placed in right-of-way. There's other places that was noted earlier as far as on the public rather than private placement, whether it be the utility poles on easements or along the streetways, whatever the case may be. Gentlemen, ladies of the commission, I do hope you take all of this very seriously as what we're trying to present to you. And anyway, I hope we can put an end to this proposed fiasco, in my opinion. Thank you for your time.
Questions from the commission? Okay. Seeing none, if we could have our next speaker. If you'll state your name and address, and you'll have 3 minutes.
Hi, my name's James Thompson, 601 South Lakeshore Drive. I'm the attorney for the Little Arkansas Community Coalition. And they've asked me to come in and speak with you because of some apparent failures of due process in this procedure that you have. And sitting here today and listening to some of the things and seeing some of the things that are going on, it would appear to me that that is in fact true, that there is some failures of due process. Oh, am I going the wrong way? All right. Yeah. I mean, everybody's protected by due process. The Constitution guarantees that first and foremost and supersedes any of the other laws that we've been talking about here today. And the reason for that is to make sure that quasi-judicial boards like yourself provide a fair hearing for all parties involved. And I'm sure everybody here wants to do that. But part of that fair process also means making sure that we have a neutral arbiter, a procedure that's in place that everybody can look up and understand prior to coming here, making sure that everybody has access to the evidence before it's presented so we don't engage in surprise tactics like we've already seen once today. Oh, went wrong way again. One of the issues that we have here is that we're relying on this 66-2019 as the law. Now, I understand your position that you've got counsel that's telling you one thing. We've also had Mr. Carmichael, though, who is a state representative, come in and say, no, that's not the way this law is supposed to be applied. I would respectfully resubmit that as part of the issue here because it is applying to public right-of-ways, not to private ownership. And it also requires the board to look at all of the criteria, the review criteria, and it does not appear in the last ruling that was sent up that was done, and I think that was one of the reasons it was sent back. But Mr. Ferris was allowed 10 minutes to come up and talk and give you different opinions on different things. He's not an attorney, he's not a realtor, he's not an appraiser. On the other side of things, though, we've had our homeowners come up who are, in fact, realtors. We've submitted appraisal recommendations and how this is going to affect property prices. And we did that in a timely manner as required by the procedure as we understand them. The other thing that I want to make clear is that the burden is on Mr. Ferris. The burden is not on the homeowners to show why this shouldn't go in, but why it's Mr. Ferris that needs to show why it should go in and why it should override all of the property interests here. And as you are well aware, 20% allows for a protest petition to come forward. We've got 81% of the people in that area that are coming forward saying, no, we don't want this in our neighborhood. It's going to affect our property values. And they provide you substantial evidence on how that's done. Failures of due process that I'm seeing here already is, I mean, one, we don't have an ability to cross-examine. Mr. Ferris got up and made comments that we take serious issue with, and we didn't have a chance to say anything.
Mr.
Yes.
Thompson, your time is up. Would you like an additional 2 minutes?
I am just about done. Yes, that would be much appreciated, ma'am. Thank you. There appears to be a lack of a neutral arbiter. And ma'am, pardon me, but I mean, I've seen Facebook posts of yours where you appear to have already decided this issue prior to coming in here. And that's inappropriate when you're talking about a quasi-judicial board. I don't think that you were doing anything maliciously, but I think talking about it and giving that appearance definitely affects the due process rights of my clients. There also appears to be some impropriety going on here based on some information and letters that I've seen from Mr. Carmichael regarding Mr. Ferris's relationship with employees at MAPC that I think prevent him from being the one that should be up here. He is not the appropriate person, I don't believe, and the people that are supposed to be applicants aren't here to talk, and they didn't sign the application. And that leads into the failure to follow the procedure for the application. And as I've already discussed the other ones, I'll go ahead and finish up there. I think that you have some serious due process concerns here that need to be addressed and properly administered. The people that have concerns that are property owners are not given the same amount of time. Again, just because that's the way things may have been done in the past doesn't mean it's complying with due process. So,
Thank you. Questions from the commission? No?
thank you.
Thank you very much. Mr. Todd, are you up next? Okay. If you'll state your name and address, and you'll have 3 minutes.
Good afternoon. John Todd. I live at 1559 North Payne Avenue, Wichita-Sedgwick County, Kansas. I am a retired real estate broker. I am not an attorney. I view this issue as a private property rights issue. We have a protest petition signed by 81% of the adjacent property owners that do not favor it, versus one property owner who either knew or should have known in advance of seeking this conditional use report what the rules are. And yes, it is an economic issue whether we're going to favor the one owner against the many, and it does have economic impact, in my opinion, on both. The value, in my opinion, is having many years' experience in the business is all subjective. I always get a kick out of people that love to clutch appraisals to their breast. Made by the members of the Appraisal Institute, MAI. In the business, we used to call that made as instructed. You can do anything you want with an appraisal, so it all depends on who's paying for it and what the need is. My recommendation is that you turn this application down today and let the governing bodies of the City Council decide. Thank you.
Thank you, Mr. Todd. Questions from the commission? Okay, thank you very much. Ma'am, if you'll state your name and address, and you'll have 3 minutes.
I will, as soon as I get this down to my level. Francine Davis Sharp, 1820 Arkansas. My family is 6th generation within the block. First, a state law, the FCC ruled that every brand of cell tower must service any brand of mobile phone, even for citizens whose phone service is turned off. Years ago, people began to switch to mobile phones and use them for 911 calling. While some people retired their wire phone service, the competition brought us new wired technology, and in the form of fiber and cable. And now Wi-Fi calling is as common as any other type of calling. And in response to the statement, quote, T-Mobile is presently located on the existing tower at Twin Lakes Shopping Center to the west of the subject property, and this tower location is designed to provide relief from capacity issues at that tower. There is also a Verizon tower at 17th and North Broadway, from which T-Mobile and Sprint also rent space on that particular tower. It is a 119-foot tower because at 120 feet, you must have a light. So this is at 119 feet. Verizon has the largest market share in North Riverside and Riverside, and me. AT&T, Sprint, and subsidiaries also provide service. Only the tower sitting representative working with T-Mobile has been looking for more tower sites here or states that they need more capacity. Of the hundreds of residents who have voiced opinions, only one indicated any problem with their cell service. I can be in my, down below my basement in my pump room, and I can still get service on my Verizon. He stated he had difficulty receiving service inside his home. However, we don't know if he lives in this area, if he's a T-Mobile user, or if he has a 4G LTE phone. All other respondents can be summed up by a statement by one North Riverside resident: don't need it, don't want it. I still have my old flip phone. It works fine, thanks Verizon. Actually, in the Riverside area, 3,264 Facebook members are in our area, and nobody seems to have any trouble. Any questions?
Thank you, ma'am.
Thank you so much for listening to all of us.
Bet. Questions from the commission? Okay. Does anybody else like to speak on this case? If, Mr. Joe Johnson?
Someone mentioned that Mrs. Willenberg had some information about demographics. Could you please present that to us?
Interested in.
Whatever you were going to talk about, you didn't have time.
Yeah, I'm kind of helpless, aren't I? Hey, I got there. Actually, I must have just gone right by it again. I'm sorry. Demographics. Okay, yeah, I didn't have a whole lot. Our neighborhood school kind of tells a lot. It has 84% qualifying for free reduced meal program, 81% minority enrollment. We love our diversity. That's why most of us live there. We value that we can do a walkable neighborhood, that we have environmentally beautiful things to look at. The little quote at the bottom was from nextdoor.com. It's an online service. They did a survey of North Riversiders. They like the river, the walkability, we have walking parks, it's peaceful, we have trees, we have diversity, the beautiful atmosphere. The aesthetics of this tower will markedly impact that. The fact that there are cell towers that are taller further away, we can't see them. We don't see the one at Waco and 21st or the one at 17th and Broadway.
Thank you. I think you answered my
Thank you.
question.
Thank you, ma'am.
Any others?
Any other questions from the commission? Okay. Mr. Ferris?
Ms. Miles?
Yes, Mr.
There's a
Blick.
gentleman that was getting up to come up to the podium.
Is there somebody else that wants to speak on this case?
I just wanted to introduce Bob Kaplan. Madam Chairman, Bob Kaplan will be representing APC Towers. He will be coming forward to do make some comments in the rebuttal.
Madam Chair,
Yes, sir.
Commissioners, my name is Bob Kaplan.
Mr. Kaplan, could you
I'm
scoot
at
over to the?
1600 Epic Center with the law firm Klenda Osterman. I was asked to appear and to share with you a legal perspective on the issues, the concerns that you have heard this afternoon and that I derive from the record. I had not appeared previously in this case. I perceive there are three matters for you to consider that are primary matters. One is the devalued property, impairment of market value, a neighboring property. Number two, aesthetics. Number three, just the general neighborhood opposition, which is a factor. On the devaluation of property, Mr. Ferris, I believe, adequately provided that. The people here objecting have no specific evidence. They have drawn general conclusions that a cell tower is going to devalue the market value of their property. On the other hand, Mr. Ferris has given you a market study professionally done. There's absolutely no reason why you should not consider that in your deliberations. Aesthetics, second point. Be very, very careful about aesthetics. I have been in several cases now that have gone to the appellate court where we've dealt with aesthetics. And let me tell you what the court says about aesthetics. First of all, they're not specifically definable. Secondly, aesthetics have been used, and I've been in a couple of these cases myself, and in cell tower cases, aesthetics can be nothing more but a vague excuse for an arbitrary opposition or an arbitrary objection. Say, well, the aesthetics are bad.
Mr. Kaplan, I appreciate your rebuttal, but your time is up.
Excuse me? My time is
Your
up?
time is up.
May I have 1 minute?
In a rebuttal, we can't give you an additional minute. Sorry. Do you all have questions? Okay.
Make a motion to extend it
You,
time.
you want to make a motion to extend for? Okay, it has to be a motion to suspend the rules of the, and extend the time. No?
Cancel that motion, thank you.
Okay.
Let me just ask a question then.
Mr. Joe Johnson.
You tell us about your third point, which was opposition.
Yes, I can do that, Mr. Johnson. Thank you, sir. The third point, I think, is the most critical and the most important point for you to consider. In the law, we call it plebiscite. And what plebiscite is in the law, meaning a vote of the people, simply said, you cannot use neighborhood opposition as a substantial reason for denial in a zoning in a land use case. It is a factor. It is a factor and you can consider it. But if a court finds that it was based substantially on plebiscite, on nothing more than the opposition of people in the neighborhood, the court will not consider it. It is not a basis. Plebiscite, it's a legal issue. The neighbors have a right to be here. They've done a fine job. I've had nice talks with several of them, but they do not know land use. They're not expected to know the law, and they simply object to it because they object to it for whatever reason. And that's not legally a reason for denial in and of itself. It is a factor, but that's all.
Other questions from the commission? No? Okay. Oh, Mr. Foster. Mr. Foster has a question.
It's a question for Mr. Ferris. I've been reviewing the materials again. Please confirm, this is going to be galvanized, correct?
Correct.
Tower. Have you been involved in other towers where the material has changed or folks find the aesthetics better by use of another material?
Well, to be honest, we looked at that many years ago, and the conclusion was that a galvanized pole was the least obtrusive in the area. While I'm not an attorney, I'm not an appraiser, I'm not a realtor, I've done about 150 of these, so I do know a little bit about how you zone cell towers. And we have in the industry and in the planning departments that we have worked with determined that galvanized is more appropriate. However, You know, if you wanted it painted brown, we'll paint it brown. That's not a problem. If you wanted a different material, but if you read the wireless plan, it specifically states the preference for galvanized, so that's why we follow the wireless plan in that regard.
Other questions from the commission?
Thank you very much.
Thank you, Mr. Ferris. Is there any, oh no, we've already went to anybody else from the audience, so I'm going to bring it back to the commission for action. Mr. Warren,
I got a question for staff.
Okay.
Exactly what are our options here?
okay?
Well, since this is a return, and Mr. Yearout can help me clarify,
Take no
but
action.
you really only have the option to reaffirm your original motion, or if you've heard testimony that you think that based on what you've heard today, you can reverse your opinion and submit a recommendation for denial with alternate findings. Anything else?
No, that's what I was going to say.
Thought you made a comment we could take no action.
No, no action would result in the original recommendation going back to the commission as originally done.
Hey, Mr. Warren would like to make a motion.
Move to reaffirm our original decision.
Second.
Okay, I have a motion by Mr. Warren. I have a second by Mr. Klossmeyer. Discussion? Mr. Foster?
You know, throughout the whole proceedings here and, you know, all the previous reading in preparation for this case, you know, this comes back to looking very carefully at the golden rules that we're to follow. And I think some things need to be looked at carefully relative to the staff report before this goes forward. For example, in number 1 here, the zoning uses and character of the neighborhood. Well, clearly it's been demonstrated to us by the neighbors and logically that, yes, the zoning does make sense, but yet the actual uses and character are completely against this. So I don't think that's correct in the report. Number 3, extent to which removal of the restrictions detrimentally affect nearby property. It states in the staff report, but no definitive finding of harm can be made. Well, why did we just get a 190-page report to help support all this? And yet we're getting conflicting information. So I don't believe item number 3 here has been properly addressed. And I do have a concern that the neighborhood folks have not even seen that information or have any opportunity here to talk about that information. Item number 6 about, let's go. In the staff report, there's not even a comment here related to opposition or support of neighborhood residents. So I think that should be added to the report, and the fact that you've got a protest petition of 81%. That is huge. It's not intended to be a vote, it's for the folks that live in and around us. So I think that should be included in the staff report. I think having thought of that, I'm going to recommend that we disapprove the application and that the staff report be updated as that goes forward to the governing body.
Foster, is that a substitute motion?
That's a substitute motion.
Second for that motion.
I'll second it.
So we have a second by Mr. Florence. Okay, further discussion? Not all in favor of the substitute motion, say aye.
Aye.
Can I have a show of hands? Okay. Opposed, same sign? Okay. Well, motion fails, 11-2?
One abstention.
I'm
I've been
sorry.
informed that I am not able to vote on this
That's-
matter since I
that-
didn't hear all the testimony, even though I've read all of the supporting documentation that's been given to us.
So,
Is that a true interpretation?
Our rule has been Mr. Green came in substantially after the neighbors have started
to present their testimony. He was not able to hear that. He has read the evidence that was presented ahead of time, but without hearing the evidence of the neighborhood, he wouldn't be able to vote on
He
that.
did hear it the first time.
Yeah, but this is a lot of additional evidence that was presented, to be fair about that. 291. No, it's not. It's 210-1. Because there's a,
That's right.
all right, we're going to go back to the
You guys
original
read it all.
motion. Any other discussion on the original motion? Mr. Dool?
Just for clarification, the reason that the city council sent this back to us is because of further clarification and interpretation of the statutes that govern the cell towers. Is that why we're reconsidering this?
There was, between the original public hearing, there was substantial evidence that was submitted by a lot of the neighbors to the city council. That's not considered a public hearing, so it was remanded back to the MAPC to hear the additional evidence that was submitted, not specifically for the reason you specified.
Other discussion? Okay, seeing none, all in favor of the motion, say aye.
Aye.
Opposed, same sign.
Aye.
So, motion carries 11-1.
2-1. And
2-1.
Okay, you're right, 10-1. I gotta count. Thank you. All right, moving on to agenda item number 7, case number CON 2019-0008.
6, I think.
What?
Oh, correct.
I read it.
Approved. We approved 7.
Something I have here doesn't jive.
Item 7 was approved on consent. Item 6 is yet to be
I
heard.
see. I got it. Thank you. All right, we have Dave here to present.
Thank you, Madam Chair. Dave Yarrett with staff. This is a request submitted concerning the property at 6601 or 6609 North Woodlawn. It is the property outlined here on the aerial. You can see the front property is zoned limited industrial. The balance of the property is all zoned rural residential, as is all the land surrounding the subject property. The red outline shows the boundary of the city of Keachai as they have annexed in the area. This is an aerial photo. Some of you may recall this property because there's been issues in the past. I think, about 4 years ago, there was a request to place a permanent asphalt facility at the location that was subsequently withdrawn. The property has changed ownership. If you go back enough in time, this was the property that was operated by the Casters for their facility up on North Woodlawn many years ago. And this shows the growth map, and this does fit within the growth area identified for the city of Keachai. And I would note, we did take this to the city of Keachai. What the applicant is requesting is the placement of a rock crusher on the facility temporarily in order to clean up an area that's along the north and western boundaries of the property. You can see the railroad track that runs through here, and they've outlined in kind of black the area that is a berm area to be cleaned up. What they have done, and you were provided a copy of a number of photos that the applicant provided showing what is on the on-site, and we actually have an earlier 2006 aerial photo of the property. before a lot of the material was covered. And you can see in this area, there's places where material was brought in and disposed of on site. The story we got is that was classified at the time as clean rubble, which I'm sure you're probably aware is material that does not require special permits to dispose of the property on site because of changes in state law a number of years ago. They classified clean rubble essentially as broken up concrete, asphalt, rocks, those kinds of material, but not material that would be classified as requiring a construction and demolition landfill site or in a sanitary landfill. The bottom line is this is the area now that the applicant is requesting to be allowed for a rock crushing facility to come in. According to the plan that they've submitted, you have that in the packet. They've got a subcontract crushing operation who has agreed to, for the use of recovered material, will bring in their portable rock crusher and clear and crush the material as they expose it, haul it out. They're only going to be on site whenever they have contracts to sell. That's what they've been have told us. They ask for a 5-year period. You can see in the staff report we recommended 2 years, but there are also limitations in the conditions as to the duration when they actually come on site of when the crushing operation will be allowed to go. According to the owner and the crushing agent, when they come in, they want to be there just long enough to make the investment of time to get there worthwhile, to get the material out, crush up what they need and can sell, maybe create a little bit of a stockpile for future use. And then the crusher will be moved to other locations where they're currently engaged in providing services to other operations within Sedgwick County and the city of Wichita. There are conditions that we have recommended. You were provided a copy at your desk of some new language that's being proposed in conversations today with the enforcement folks. They felt that the language proposed as drafted in the staff report left a little bit of vagueness that was felt would be better enhanced if we add a little more clarification. So we provided you new language for condition 6. Primarily what we tried to do there with the last sentence and modifying the first one was to say that the requirement of watering and providing other dust suppression would be while the actual crushing and operations were occurring on the property, that it wouldn't apply if they were not actively on site, particularly since if this is a 2-year period, but they're only to be there like for 2.5 to 3 weeks at a time. It's only when they're operating, it's when the dust suppression requirement is there. I will note that yes, we have neighbors here. We also have a representative from the city of Keachai. The Keachai Planning Commission did hear this case, and they voted, was it 4-1 or 3-1? 3-1 to recommend approval as we kind of outlined. They were concerned about a limitation up to no more than 2 years, which is in the staff report. And I think that was the only real issue that they had was the time limit, as much as I recall. Anyway, Mr. Moreland, who is here on behalf of Keachai, is here. The applicant is here, and so I'll be happy to answer any questions you've got.
All right, questions for Dave? Mr. Joe Johnson.
A time limit is perfectly legal?
Yes. We can put a duration not only on the overall length of the permit, but also the operations of when they're actually occurring. There were also concerns on the other issue was the hours of operation and the Mr. Martin, who is the one that has the crusher, had indicated that he was wanting 7 a.m., but he didn't want to go past 5 o'clock because he didn't want to pay overtime, I guess. So, and he would not be there. And then we talked about in our recommendations that it was limited Monday through Friday, no holidays, no weekends. However, they can be there which is what Mr. Martin had asked for, that he does have, if the equipment needs attention for maintenance or whatnot, they might show up until noon on Saturdays, but that they would not run the crusher. It would only be for maintenance purposes.
Other questions for Dave? Okay, thank you, Dave. If agent or applicant would like to step forward, and if you'll state your name and address, you'll have 10 minutes.
Out here.
I'm Dennis Simmons. My address is 8403 West Meadow Pass Court in Wichita. In November, mid-November, I acquired the property at 6609 North Woodlawn. That is owned by DSP Investments, which is an investment company of mine, which is subsequently leased by my trucking business, which we do run and operate at the current time 7 semi-trucks out of that location. When we purchased this property, we understood that this was a big pile of dirt mostly, with some rock in there. Shortly after purchasing the property, I was approached by Mr. Martin and informed of what was truly buried back there. We're just looking at coming in, cleaning this up for a possible future home site, with as much concrete and stuff that is buried in there that would be absolutely not going to happen, I guess. Some of the concrete, yesterday my wife and I walked this property and got on the backside where the railroad tracks are, and you can see everything exposed on the backside. There's cement pillars that are 3 times as big around as I am and twice as tall, full of metal, wiring, conduit that comes through it. These are light poles that were excavated from gas stations. Whenever the tanks, I guess the underground fuel tanks were excavated due to regulations and stuff, the parking lot and things like that were brought to this facility and disposed of when Castor Excavating owned it. I know some of the neighbors are very concerned of what may be buried there. I would prefer if something was true, that there was something disposed of that wasn't supposed to be, we would get it out of the property, remove it, dispose of it properly, according to the state guidelines or whatever. I'm not a rich man by no means. I would hope that there's permits that were pulled that kind of protect me as a future landowner, that I don't incur all those costs. But if there is truly something there, I would want it out of there as well as I would think my neighbors would. I know some of my neighbors are very concerned about the noise level, things like that. I have submitted the rock crushing decibels and things like that. From my understanding, within 30 to 50 feet of this machine, you can carry on a normal conversation. I have not personally been around one. Mr. Martin is not here today. He had some other health issues that he had to take care of, had a conflicting doctor's appointment. He told me that he is currently crushing in the city of Derby, across from the city office, right next to a school. He's crushing during business hours. Kids are playing on the playground while the crushing's going on. The water that is put on this product as it's being crushed keeps the dust at an absolute minimum. The metal is then magnetized out of the product and recycled as well. Everything that my wife and I are looking to do is just to clean up this property. It took 20, 30 years, I don't know how long that permit was in effect, that Castor came in and dumped things on this property. We're just asking for a decent timeline to remove the product out of there, which will take some time. It is not cost effective to truck it out. You would truck out 10 trucks worth of raw material to get one worth of finished material. I'm in the trucking business, and I can tell you that is not cost effective. If it was, I would absolutely do it. I did not buy this property to come in and create conflict with my new neighbors. I'm just trying to clean up what I acquired. It's none of my doing. I'm just hoping to set it right and make the right choice for my neighbors, my community, and be a good steward of the land that we purchased. And I think that's all I have.
Questions for Mr. Simmons? Mr. Foster?
What's the desired time limit that you would like for this application?
Originally, due to previous downturn in the economy, we were seeking 5 years. The crusher comes on site roughly 8 to 10 days, 12 days max at a time, crushes an amount that they have sold, and then stockpiles some for smaller jobs so they wouldn't have to bring it right back in. And it's just trucked out as needed. Whenever they're doing their main part of crushing, it'll leave that same day as it's being crushed. The reason I asked for the 5-year deal is just because we got an election again in 2 years. You know, we've came out of a bad economy, that this product didn't sell as well just because construction was down and everything. With construction being at an all-time high, after reconsideration, Stan, the crusher, and myself, and people that we've met with have told us that we feel pretty confident. We can get it done in 3 years. We're asking for 2 to try to be accommodating to the neighbors and the city of Keachai of their recommendation. We've been told that part of their recommendation was a possible 1-year extension. If we need that, I think that the neighbors would maybe be a little more acceptable of that, because they will understand maybe it's not as bad as they're thinking it's going to be today without knowing what's going on. So we're very confident in the 3 years we could have it done. If we needed to light the fire a little bit to get it done, we may just have to come in the finishing little bit and spend the extra money to get it just done and stockpile it until we can sell it. But that's not something that I incur cost-wise. This doesn't cost me a dime to open my gates up and have this product removed. This is 100% on Mr. Martin's company, that he acquires all expenses of this.
Questions from the commission? Okay, thank you.
Thank you. Have a great day.
Anybody from the audience that would like to speak on this case? Yes. Okay, if you'll step forward to the podium, state your name and address, and you'll have 3 minutes.
My name's Frank Dungan. I live at 6522 North Woodlawn, essentially across the street. And we certainly applaud Mr. Simmons trying to clean up his property. We don't object to that whatsoever. We would like some assurances, however, that the project does not become a nuisance, because we had some history with that. It has taken place. Essentially about 4 points I'd like to address, just to make sure that we can stay on amiable footing with him. We'd like to be very good neighbors. We've heard some discussions on noise control, but I haven't heard any numbers. I would like to apply some numbers to it. Did a little bit of research, and from other places that have been used, places have been recommended no more than 100 decibels within 2 meters of the machine, and 75 decibels at the property line. I think that would be acceptable. Dust, by the way, there was some discussion on dust at Keachai. OSHA does call this a carcinogen when you crush concrete. It has high levels of silica in it, and it can do damages to, say, automotive paint, that type of thing. I would like to say that, put in a proviso, I guess, for that there would be no discernible amounts of dust that would be leaving the property. So it's not going to contaminate grazing land or outbuildings, automobiles, that type of thing. Actually, a question too, is this going to be ground to a powder? Is it going to be, say, 1/2 inch, 3/4 inch? I'd be curious to know what the end product might be there. Next one, who's responsible for testing? Who do we talk to if there is a complaint? And we're not comfortable at the time on the permit. I think 6 months for a temporary permit, with options to extend it if there is no objections or complaints lodged. And I think that would take care of most of our concerns right there. That's all I have.
Questions from the commission? Thank you. Is there anybody else from the audience that would like to speak on this case? Yep. Okay. No worries. And if you'll just state your name and address, and you'll have 3 minutes.
Yeah, I'm Loretta Seibel. We live at 6401 North Woodlawn. We're directly south of the property. And, you know, I want to be a good neighbor also. I have nothing against the Simmons personally or anything like that. And I am certain there will be a rock crusher in my backyard. And I am very disappointed with that. I dread it terribly, and it is going to impact us greatly. There is not one of you commissioners, Mr. or Mrs. Simmons, who want a rock crusher in their backyard. If I wanted to put a rock crusher in their backyard, they would be doing what I'm doing. They would be talking against it. Regarding the Keachai meeting, I have several things that I would like to say. Mr. Simmons said in his report at Keachai that the neighbors to the south will be the ones most impacted by the noise and the dust. And several times he said the machine is not real noisy. And you do have a copy of the Keachai report probably there with you. Mr. Simmons said there would be much less ruckus than the crusher previously used on the site. Mr. Urout stated that he feels it is tainted by previous operation. I am not weighing this against that. There are enough reasons to be opposed to the concrete rock crusher on its own. Mr. Martin uses a 320 SR crusher, but he did not have the decibel rating at the Keachai meeting. I looked online, and most of the recorded readings are 93 decibels. Mr. Urout, Mr. Siemens, and Mr. Martin and neighbors have all heard stories about what is illegally buried under the concrete rock piles. Mr. Urout said, if undesirable materials are found, the county, state, federal agencies would be notified and determine, based on the nature of the materials, how to properly dispose of them. If they dig up non-permitted material and waste material, I want written regulations on how that is to be reported and handled. And I ask, who will and how often will these be tested? Concrete often has asbestos in it itself, so who's going to even, you know, who's going to be checking on this? And we just heard from Mr. Urout too that there will be and from Mr. Simmons that there will be a stockpile left on the property, okay? And if I understood right, what you said, Mr. Urout, is that only while they are grinding, is that when they're required to do the water treatment to keep from dusting?
Ma'am, your time is up.
Can I have 2 more minutes, please?
Sure you can.
Thank you. But anyway, so that's what I'm wondering, you know, how the stockpile is going to be monitored for dust. And my brother Bales, the brome pasture, back there right adjacent to that, he does not want to feed his cattle cement dust. They are not steers going off to market. They are his cow-calf herd. According to Mr. Simmons, one statement, there will be cement dust. He said it. Our own horses eat this all year round. I will have our grass tested before it is baled. And Mr. Moreland expressed concerns with noise and dust and recommended the limit is used 2 years or less. Mr. Mattson, landowner to the east, recommended 9 months should be sufficient. Therefore, I respectfully submit my request and ask that you reconsider and consider issuing the crusher a permit for 6 months, beginning July 1st, 2019. This would allow for my brother to bale the hay without cement dust this summer. And then he will probably make a decision whether or not he wants to rent from us in the future, because if this goes on for 2 or 3 years, he does not want cement dust on his brome hay. the work could be done. It is said in many, in other reports that this work could be done in 6 weeks, and the entire project could very likely be done in less than 1 year. They indicate economy, this is economy driven. If they require more time, let them ask for an extension. And if everything is going fine, nobody's going to go against that. I believe 6 months permit will give incentive to get the work done in a timely manner, thus disrupting the neighborhood as little as possible. Thank you.
Thank you. Questions from the commission?
Question.
Mr. Hartman.
On that map, does your house show up?
Gerald, does it show up on the map? Can you show them where? I have one in front of me, but I don't know how to.
You move the mouse.
Gerald,
Their property is right here.
yeah. Yeah. And so my brother, we have the ponds. Okay, now I just moved this. Can you put it back? Yeah, I'm pretty done with this. Okay, now how do I get back to here?
Well,
Just
this
right like
is,
that?
this is the Brome field that she's talking
Yeah.
about. They own all this property south. This has been carved out as a separate parcel for tax purposes because of the house, but they
Yeah.
own the rest of the land.
Yeah, so back here then, that is where this whole field here is brome, and then that is all baled and so I'm serious, I really don't want dust on the brome going to the horses and cows. So thank you. Any other questions?
Any other questions? Mr. Foster?
I want to understand your thought about July 19th, or I'm sorry, in July. You're saying that he would have his baling done by the beginning of July, end of June?
Yeah, the beginning of July, the baling, and that again, it's seasonal. There is a perfect time, there's a good time for baling, and we farmers, we know when that is. And, you don't want to bale it before it, and you don't want to bale it too much after, but by July 1st, for sure, the baling should be done.
Thank you.
Other questions from the commission? Okay, thank you. Is there anybody else in the audience that would like to speak on this case? Yes? Sir, if you'll state your name and address, and you'll have 3 minutes.
My name is Gerald Seibel. I live adjacent to the property, 6401 North Woodlawn. I don't have much to add that hasn't been said. I guess dust is a major concern, like my wife said. I'm not sure what we do if it is a problem, and do we just wait and see if it is, or what? I'd also like to ask for the 6 months time period with extensions if needed. Nobody wants to live next to a rock crusher, even a temporary one. I've talked to a local owner of one here in Wichita, and he said he wouldn't want to live next to his, so I guess that's all I have. Thank you.
Questions from the commission? All right, thank you, sir. Is there anybody else from the audience that would like to speak on this case? Okay, if not, if agent or applicant could come forward, and you'll have 3 minutes rebuttal. 2 minutes, sorry. I'm in that 3 mode, but it's actually only 2. But you don't have to state your name and address again, so that saves you some time, right?
I understand my neighbor's concerns. The 6-month timeline is just, it's really unrealistic. This pile, I'm 100% certain there's concrete everywhere because a lot of it's exposed on the backside, so there is concrete in there. We don't know if we're gonna get in there and dig 20, 30 yards across this thing and find nothing but dirt. I talked with Jeff Castor, the son of the former Maurice Castor. He said they dumped everything in there off of job sites. If they went in there and cleared the grass, getting ready to build something, all that dirt, they didn't pay the dump fees, they brought it to their own property. If they tore up the parking lot, the concrete came out here. It is permitted, clean rubble. like I said, Mr. Martin is crushing next to a school right now in Derby. Anybody's willing to go down there and look at that. If they're not real concerned and the dust is a major issue, I don't think they would be letting it go on next to a playground with kids outside during the day, because it is a daytime crushing operation. I understand the concerns, but it will be, there's regulations that Mr. Martin has to go by from KDHE and other places, that this is wetted down as the crushing is going on when it makes dust. One of the things was ask how big the rock was. We are looking at 1.5 to 2 inch rock. Of course, there's going to be fines and stuff that come off of that. That's just the nature of crushing a nut in your hand. You're going to get small pieces and big pieces. They're going for the bigger pieces. That's what they use for base for parking lots as well as other things. So we're going for a little bit bigger rock and trying to keep the dust at a minimum. I haven't seen Mr. Martin's crushing personally. I'm just going off of what I'm being told by him and his crew. I'm not sure where we go. It sounds like all the neighbors are vested in getting it cleaned up, and I'm just hoping that we can get a little longer timeline than 6 months, because I just don't think that's feasible to even start.
Okay, thank you. Mr. Hartman?
I have a question. Do you have an idea on where he'll be locating that crusher on site?
The crusher will move amongst the site every time it comes in, but he indicated he's going to set up roughly in here, in this area.
Yeah, you need to move the mouse here.
Oh, sorry. Got to do the mouse here. So roughly in front of this dirt pile is where every time's going to be. It'll go onto a conveyor up to the crusher. So he's roughly looking at 1, 2, 3, and possibly 4 spots. It depends on how much material he pulls out at the time. And if it's a whole bucket of nothing but dirt, it goes through a screener that he has on site, which is my understanding. It's a big angled deal made out of pipes so that sifts the dirt through, and the material, the rock, falls to the base of it where he can pick just that up. So it's not just running just dirt and trash through his machine, and that will then be put back on the property as a whole lot smaller, clean berm than is currently there. The pictures don't do this justice. This is 45 acres, and if you look at this, probably a third or better of my property is covered in whatever is there. It's ridiculous.
Now, would you have a concern on, you said 1, 2, 3, and 4 sites on where he started? It seems to me if he started at the north end, that he would be less impacting the brome field to the south, and normal wind conditions are usually from the south, so I think, majority of your dust particles would be away from that brome field. I don't know if that would make any difference or not.
Yeah, we can start, if there's a recommendation to start somewhere, I don't think any of us have a problem. We're hoping to excavate it all out of there. But you're correct, in the summer, the wind is out of the south. It's gonna blow mostly to, my neighbor to the north would have the majority of a concern, which he called me after he got his letter and told me that he understood what I was doing. I'd talked to him as well as Gerald to the south, and expressed what we would like to do, and he said he wasn't going to attend any kind of meetings. He had no dispute over what we are trying to accomplish.
Mr. McKay? I got you, Mr. Blick, next.
Sir, have you used some machinery or anybody to see what's underneath your rock and stuff there?
No, sir. There's 3 rock crushers in town. Fremar is one of them, which is a brother to Mr. Martin. They ventured off and decided to split and do 2 different operations. And then there's another gentleman. I've contacted all 3 of those, all 3 of which would like to come in there and poke some holes in this dirt and figure out what it is. I didn't know if we could legally do that without obtaining the permit. So that's why I'm here going this avenue first, is I didn't know if we could even go in there and disturb this pile. So we did not do that.
You really don't know. The reason why I'm asking these questions is because I'm very familiar. I used to live up there in 7200 block of North Oliver. Mr. Castor used to have a crushing system already there for lawnmowers, for washers and dryers. he was made to move that, and he put it where the old Derby refinery used to be.
Yes, sir.
Just off of I-35. And so I'm just wondering, if we're opening Pandora's box without somebody saying, hey, I've gone up here and checked, and there's dirt underneath the rock, rather than trash and all kinds of stuff underneath there.
Sure, and from my understanding, that was a shredder operation to recycle metal.
Yes.
Which was then opposed by a former neighbor to the north that spent a lot of money to get Mr. Castor out there, as well as some other neighbors. And I'm pretty dang certain there's not a lot of easy money metal in this pile. If there was, Mr. Castor would have ran that through a shredder. I really don't think, other than rebar and the stuff that's made into the concrete, is what we're going to find as far as metal goes. I have not, on top of the surface, seen any of that. Now, I have been out there. There is a pretty large pile on top of this, as far as somebody brought out, I guess, their shingles off of a roof that have been dumped out there. That will not be part of this cleanup deal. We will either rebury that or haul that off to the dump. It's mainly, we're after the concrete. From what I've been told by Jeff Castor, that this was heavily regulated by the county and the permitting department. They would show up at random times. Mr. Castor and the inspectors had several battles, if you will, because the inspector would want to go straight to the pile and not check in at the main office. Mr. Castor didn't like that, but I personally like that, because if they were trying to hide something, I feel that they would have got caught. He may not have liked it, but like I say, I sure do.
Not asking if I did it on purpose or anything. I'm just saying the remnants, they're sitting there talking about dust and powder from the concrete. I can imagine what kind of shavings or whatever it might be still be in the ground that's there, because Castors were forced to move that operation from there to where they went. They just got fortunate enough to be able to get all the metal from Derby refinery that was torn down. So that's my only concern. If anybody has checked to see if there's anything underneath the rock, regardless, I'm not talking about illegal or anything else, just for protection of anything else that's around there, because that could create more problems than the dust that you're talking about.
Sure, and the concrete crusher was actually, the shredder, not the concrete crusher, is right along this line up here. There's a little small lagoon that is for the parking lot and drains in the building that have been since filled in. I personally filled those inside the shop. But right behind that, if the mouse will work, right here, there is a huge cement ramp that is built that the shredder and stuff was on. All this that looks like dirt around here, this is actually all concrete around here, clear up to the front of this building. Pretty much this entire area is all concrete, something like 10 acres. And that was where his shredder was set up, not on the back of this property back here.
Not true. Not true at all. I've seen it back in the northwest corner of your piece of ground, because that's where the main stuff was brought in from the road and dumped. Because it was piled high enough you could see it from Woodlawn.
Okay, that's news to me.
I'm just saying to you that may be where it was eventually, but the northwest part of that piece of property is where it was at mainly.
Okay, I'm just going by what I was informed by Jeff Castor.
I understand that, but I'm just trying to say to you,
Sure.
I know for a fact that that's where it was at.
And I talked to Jeff Castor when I talked to Jeff. I told Jeff Castor, I said, you don't have a dog in this fight, and I understand you guys are out of this property. I said, Jeff, if you tell me do not disturb this pile, because I might find something that I don't want to uncover, I said, you just tell me to leave it alone, and I said, I'll walk away. And he said, Dennis, if you want to crush that rock today, go for it. He said, if I were you, I'd wait 10 years till the price doubled. And that's his exact words to me. And I feel that since he doesn't have a dog in the fight, really, it doesn't make a difference to him if it's uncovered or not. I would hope that he would have been honest with me and just said, don't touch that pile. And we wouldn't even be here today.
All right, Mr. Blick.
Sir, do you agree with all the staff's recommendations, hours of operation and all that?
Yes, sir. 7 to 5, Monday through Friday is very feasible for us, according to Mr. Martin. Those are his hours of operation anyway. He would like holidays off as well as myself. He prefers to take weekends off. It was mainly just Saturday till noon to repair equipment that had, this is not easy on equipment, so he would like Saturday till noon to just repair his equipment. So it wouldn't be like if the machine made noise that it would be crushing. It would be maybe turned on to grease it or to service it, but absolutely no rock crushing on Saturday or Sunday, and we're absolutely okay with that. The 2-year with an extension, I personally don't know what that extension cost. My company and my wife and I have poured out several $1,000s on this to try and obtain this permit already. We've put out money. I don't know what that costs me every time I need to file for an extension, and that's why I personally am trying to go for a 3-year recommendation. I know they've recommended 2 with a 1-year extension. If that extension doesn't cost me anything, I'm okay with 2 with an add-on later. But if it costs me money every single time, then I'm just spending money if I could just get it done at one time. I hope you would see that. Like I said, I'm not a rich man. I'm a small business owner. Purchasing this property was a huge step for my business that I'm hoping I can grow into, and I hope I can make it work before the bank comes knocking at the door too hard. Thank you.
Joe Johnson.
I'd like to make a motion that we accept the staff's recommendation with the new language that was passed out to us to be added, and with one modification. I'd like to allow 1 year instead of the 2, but still with the extension that staff could extend it for 1 year without cost.
Have a second on that motion.
Clarification. You say just a 1-year permit?
To start with the staff having the right to extend it 1 year.
I think that that's awful tight. I don't know if they can get anything done, or what they want to do.
2 years?
2 years with a 1-year extension, I think is fair, is realistic.
Bill Johnson, did you have a comment?
I agree, and that's what Keachai approved, so I mean, I'm in favor of that, especially when it's a conditional use to do it. The property owners got everybody to call if something ain't going right to get this thing shut down, so I don't have a problem with that.
I'll withdraw my motion.
The other thing is, I don't like to base it on people that I know, but I've been around Jeff Castor for a long time, and he's a straight shooting young man, and I trust what he would tell the owner.
A motion?
Yeah, I'll make a motion to approve per staff comments.
With this addition?
Yes.
With yes.
Second?
Okay, I have a motion by Mr. Klossmeyer, a second by Mr. Joe Johnson, and a comment by Mr. Green.
Could I clarify, do you have an extension after the 2 years, or is it just?
It's
in the
the
staff.
2 years with.
In staff comments.
With a 1-year extension, yeah, it's what Keachai agreed to.
It's in there, okay.
I've got a question.
Mr. Green.
I've got a question for staff. One of the speakers was asking about the testing of the material and if there are any complaints. Could staff address who those complaints would go to if there were any concerns?
Any complaints or any questions, please don't call us. Would you contact the county enforcement officer, which is currently Kelly Dixon, who is here.
Oh, Kelly.
So, or just call generally the codes office at 660-1840 and ask for Kelly or whomever that handles the rural areas. And I talked earlier with him about the question of if there was some kind of material found that was beyond just the clean rubble. Call Kelly, and he said the first call he would make after that would be the KDHE anyway. So, yeah, their office is well connected to bring in the other entities rapidly. I mean, we've got a county environmental section that could also be brought to the site if needed to.
Okay, I know I saw other hands up for questions. Was that Mr. Dool?
Well, that partially answered my question, but with regard to compliance, is anybody going to be regularly monitoring this, or is it going to be on a basis of a complaint?
It would be, Kelly, do you want to address that at all? I mean, if there, the advice I've given in previous conversations with the neighbors that I've had personally raising that question would be, if we rely upon true city or county on the eyes and ears of neighbors, because inspections are complaint driven. So if there's an activity or event that is of a concern to someone, they need to call in immediately to the officials to say, we got an issue out here, you need to come take a look at it, and they will. And that would be how you start the process. They call us, I suppose we could call Kelly, so, but please don't do that.
Yeah, just call Kelly. I saw that over there. Mr. McKay.
Dave, did you say, and I'm sorry I didn't hear all of your comment, but did you say to the people out here that address or telephone number?
Yes.
Rather than to us? Because they're the ones who would be filing complaint.
Yes, I've shared it with them.
Provide
and-
that with, okay.
Yeah, and anytime we get a call that's, addressing an enforcement issue, yeah, believe me, we know the number downstairs real quick.
Mr. Foster.
Just real quickly, looking at the information here, it doesn't look like this is going to take very long in the sense 30 to 50,000 tons. We're only talking 3 events here to get this taken care of. I just want to make sure the noise and the dust issue that was mentioned by the neighbors, that will be part of this complaint aspect of it if something does come up.
The county has no noise ordinance, so there wouldn't be, that would be a civil matter
Yeah.
between the complainer and the applicant. The dust issue, that would be based on a complaint. Kelly would go out and determine whether or not they're complying with the water requirement. But the way it's written is they would only have to control the dust on any piles or any rock crushing when they're actively crushing.
Final question is, I really do see this concern about the brome in terms of it getting dust all over it and basically causing economic harm to the neighbor. I would suggest, and I don't know if we can put this into the motion, but that the applicant work with the neighbors on his timing so that they can actually get a crop.
I suppose one approach would be, as she indicated, since I know a little bit about hay for horses, that you could say there could be no rock crushing or that rock crushing is only permitted from, July 5th or whatever, the middle of July, whatever time period after the brome has been cut until the spring when the grass starts growing again would be one approach. I don't know whether that actually works or not, but that would be one way, is just to limit the window of when the crushing could actually be done.
I'd like to ask you a question. Please provide a time period that could be added as.
Ma'am, you'll have to step up to the podium because we're recording and they won't be able to hear. Thank you.
Yes, the reason I gave the time frame I did was because by July 1st, the brome will be baled, be cut and baled, and the bales could be moved off. And generally around April 1st is when you fertilized and we get our green start coming up. And like right now, it's growing like crazy. And so usually the time frame for brome is between April 1st, and then it's done by July 1st.
If there was a condition to limit the activity for July to the end of March, that would work then?
Well, that would be better for farm use, yes, for brome hay.
Thank you.
Because he actually does sell some of that, and I don't want him, and he may actually not want to rent it anymore if there is the potential of dust on it. Thank you.
I would just request that the motion maker add that as a condition just for this.
If we're going to limit the time in there, then we need to extend the time of the permit. Because if you're going to cut him down, yeah, have the applicant go back to the microphone, please. Do you have or Mr. Martin have a time frame once this is approved through, and go through all the channels, which is going to take another month or more, to get started? Are they going to start right away, or what's their schedule?
Mr. Martin implied to me that he has the first round already contracted for contracts that are coming up in the future that are on the northeast side of Wichita. They try to truck this as little as possible to keep the cost down, but as you all know, the prime selling season for any kind of building material is the exact time that the neighbors would like it to not go through. So if we're wanting to do this in a timely manner and keep it to the 2 years, possibly with a year extension, Mr. Martin is not just spending money to crush rock and leave it there. He's crushing as he has contracts to sell it. So I don't know if that conflict is going to work. It would be very difficult to make that work because we're just not building Home Depots and school parking lots in the dead of winter if we can help it. You can't pour concrete and stuff that this base material is designed for.
Thank you. I'll leave my motion as I stated.
Okay. All right, any other discussion? If not, all in favor say aye.
Aye.
Opposed, same sign. Okay, motion carries. 12-1, 11-1. Go. Anything else that you gentlemen want to discuss?
Ability to count the people here. That's Chuck's job.
You're falling down on the people. Don't be keeping down on the people. All right, if there's nothing else, we are adjourned.